Thanks for coming, everyone. I'm Matthew. I'm a barrister at a place called 39 Essex Chambers, and I specialise in education law and law in something called the Court of Protection, which is a court you may or may not have heard of. It helps make decisions for people who, for reasons of lack of mental capacity, can't make it themselves. But my main practice is in education, representing individuals, schools, universities, central and local government, all whole host of organisations that have a role to play in education. And I'm going to talk to you today about what you can see on the slide. So SEN units and resource provision, is there a difference, and are either compatible with the principle of inclusive education? The aims of today really are to answer four questions, and these are the four questions that were devised by, I think, Michelle in the first instance, and then refined perhaps slightly by me to give me an opportunity to put a legal spin on it. So we'll look at one, is there a legal distinction between SEN units and resource provision? Two, how are both implemented in practice, and is there any evidence of overlap between their approaches? Number three, how compatible are SEN units and resource provision with the presumption of mainstream education? And when we cover that, we'll cover what I mean by the presumption of mainstream education. And lastly, we'll look at how consistent with either of those types of provision are with the principle of inclusive education in Article 24. Now, you'll see when you look at the questions themselves that each individually has its own thought process behind it, but ultimately Michelle is inviting me through her questions to give you all my view on whether what's going on in practice is in fact a breach of international law, and it may be that I can do that later on. Obviously, everything that I say today is my own. I'm going to be endeavouring to use, and have indeed been encouraged to do so by Michelle and Edmore in the preparation of this, to use the language of the social model of disability, which I know is something that certainly Michelle will be delighted with me doing. There may be times when I don't use that. It's not meant discourteously to anyone. It's probably more that I'm quoting from documents that don't use it. So let's start then with question number one. What actually is an SEN unit or resource provision? Well, what's really interesting from my perspective as a lawyer is you tend to get asked, in all honesty, the same things over and over again. And often questions that you get asked are either really novel or not novel at all. And when I had the question posed to me, well, what is the legal basis of an SEN unit or resource provision? I thought this would be relatively straightforward. I'll have a look in the Education Act 1996 or the Children and Families Act 2014, and the answer will be somewhere in there. However, when I began my research, it turned out that the question that had been posed was a good one. And that's because certainly in my view, from a legal perspective, it's entirely unclear what an SEN unit or specialist resource provision is. So by way of background, and putting further and higher education to one side, the three key pieces of law that give the legal definitions of various types of educational institutions are the three on the slide. So the Education Act 1996, the School Standards and Framework Act 1998, and the Children and Families Act 2014. And if you want to take a look at those documents, you will find the legal definitions of a whole host of things: academies, mainstream school, maintained school, middle school, nursery school, primary education, secondary education, primary school, special school, and an entirely separate definition of school. Nowhere in any of those Acts of Parliament is there a reference to so-called SEN unit or specialist resource provision. And that's particularly notable, I think, in the case of the Children and Families Act 2014, because if you look at that act, you'll see that Part 3 is effectively the legal regime that governs how local authorities are legally supposed to support children that, in the Children and Families Act, are referred to as children with special educational needs. So you would think that if the definition of SEN unit or resource provision was going to be anywhere. It would be in one of those Acts of Parliament, but it's not. Relevant, of course, because Acts of Parliament are what Parliament has created and what should be being put into place. So I then went on a bit of a wild goose chase, looked at all of the secondary legislation. So that's things like the special educational needs regulations. And again, there's no definition of either in there. So I then had a look at various pieces of what lawyers call case law, i.e. the reports of court decisions, effectively, where people have sued other people. The court's looked at what's going on and has made a decision. And in England and Wales, generally, if something is not defined in a piece of written law, like an Act of Parliament, some clever judge somewhere will have come up with a definition themselves within a case. However, when I looked through the cases relating to what lawyers call special educational needs law, in particular, case law coming out of the High Court and the upper tribunal that considers what kind of institutions can be named in EHC plans, I was reminded of something that I'd forgotten, which is that actually an EHC plan can only name a school.
Yeah.
And as I've explained earlier, what is defined as a school is defined in the statutes. Now that's rather awkward because often SEN units or resource provision do end up in EHC plans, which is a separate question. But the point of it all is that nowhere that I can find, and I've been doing this for a long time, nowhere in law can I find a legal, strict definition of an SEN unit or specialist resource provision. And what that means from a legal perspective, in theory, is that they don't have legal definitions, they're not legal entities, they're not a thing. So to the extent that a question posed to me is what's the legal difference between an SEN unit and specialist resource provision, the answer is there's no legal difference because they don't actually appear to be legal creations at all. Now that really got me into a bit of a tizzy because these things are used and the vocabulary of them is used extremely regularly. So I then decided, well, if it's not in an Act of Parliament, the next obvious place to look for a definition is the executive or the government. So what does one do when they're looking for a legal definition in government papers? Well, the starting point for a lawyer is to look through various legal databases. However, there was nothing within those. And after a couple of hours of looking around online, I took what is the legal last resort, not using AI, but using Google. And I spent some time on Google searching around within DFE documents to try to find where the original explanation of these institutional ideas had come from. And the earliest document that I could find that's still maintained by government, bearing in mind data protection and the fact they archive and get rid of lots of things, was the document that you can see on the screen. DFE document called Area Guidelines for SEND and Alternative Provision, including special schools, alternative provision, special resource provision and units, Building Bulletin 104 from December 2015. Now, this document is interesting because it's dated December 2015, which is after the implementation of the Key Act, the Children and Families Act, in which the legal rights of disabled children in terms of their education are found. But what you'll notice is the document is called a building bulletin. What is a building bulletin? Well, the document itself explains that it sets out guidelines for effectively the grounds of educational settings, SRPs and units, and the aim of the document is to assist those designing new buildings, completing refurbishments or conversion projects. In other words, it's a document designed to be looked at by architects, engineers, builders when they are building schools. Now, what was interesting is when I looked in the glossary, I found two definitions that had eluded me in all of the relevant pieces of law that I'd looked at. SRP, specially resource provision in mainstream school commissioned by a local authority. and unit, not SEN unit, just unit, a designated unit in a mainstream school commissioned by a local authority. So from there, I decided, well, I'm in at least something the right region in looking at this document. So let's actually read the thing in full, bearing in mind it was about 160 pages long. So when you look through the guidance, what does the guidance say? Well, having gone through it in detail, I found this extract. There is a difference between SRP and units. In SRP, pupils spend most of their time, usually well over 50%, in mainstream classes. They only attend the SRP facilities for individual support, to learn a specific skill or to receive therapeutic support or access to specialist equipment. The facilities can be in a suite or dispersed through the school. On the other hand, pupils in a unit spend the majority of their time there, i.e. in the unit, only attending mainstream classes for a few lessons. Pupils in both settings are on the roll of a mainstream school. So it's clear when you look at this document, which is designed to be used by people who are building the buildings in which our children are educated, that there is a difference between SRPs and units. But before we think about what those differences are, let's look at the next document. I then found, later in time, an old school census guide from May 2018. And again, the thought process being, well, this is a document that's gone out to educators to help them fill in the relevant document. There should be, realistically, some explanation of the kind of settings that might be being included within the census. So I looked through this document, and again, and I've given you the paragraph references on the slide if anyone wants to go away and look at it in their own time. There again was definition in relation to SEN units and not specialist resource provisions now, but just resource provisions. And there are, you'll note, some similarities between the building bulletin document that I've just taken you to. So in relation to SEN units, they are special provisions within a mainstream school where children with SEN are taught mainly within separate classes. Note they're taught mainly within separate classes. They're designated by a local authority specifically for making SEN provision to cater for the specific types of needs and are usually for pupils with what nowadays we'd call education, health and care plans, what before 2014 were called statements of special educational needs. Distinct from SEN units then were resource provisions, places reserved at a mainstream school for pupils with a specific type of SEN, taught mainly within mainstream classes, but requiring a base and some specialist facilities around the school. So, looking at these two documents, different years for different purposes, but both talking about the same kinds of thing, it is immediately obvious when you look at what those definitions are that there is striking overlap, similarity between SEN units and specialist resource provisions. What are those differences? Well, what are those similarities? Both are provisions that are situated in place, i.e. on the site of a mainstream school. Pupils who are in both will be on roll at a mainstream school. And I would say it's worth noting, I suspect if someone from the government was here, maybe they are, I don't know. It's worth be noting from a governmental perspective that I suspect they would argue that that fact alone, i.e. the fact that pupils are taught within the environment of a mainstream school, or at least on a mainstream school site, that is enough for inclusion. I disagree, but we'll come on to why that is. What is plainly obvious, I would suggest, with both of these definitions, is that there is, regardless of the citing of the relevant institution, the SEN unit or the resource provision, regardless of the fact it's cited on a mainstream school and that pupils are on the school roll of a mainstream school, it is plainly clear that there is an intention and likely to be in practice as well, segregation of disabled children from their non-disabled peers in both scenarios. It's explicit. If you think about the previous slide, in SRPs, pupils spend most of their time in mainstream classes, well over 50%, but it's only most of their time. Inherent in that is the suggestion that for some of the time, pupils who are in the SRP or are resource provision pupils are not spending time in mainstream classes. Of course, it's even more obvious in the case of pupils in a unit because they spend the majority of their time in the unit, only attending mainstream classes for a few lessons. So in both cases, students are on the site of a mainstream school, but are not in fact being educated full-time alongside mainstream peers. So going back to the question that I was asked, well, we've established that SEN units and resource provision are not legal creations. They are, it appears to me, governmental creations as a mechanism, presumably, to meet the needs of disabled children in mainstream schools. That's the theory, but what then is the practical reality? Now, for me, this is a difficult question because, yes, I'm an education lawyer, but what I am not in any way is an educationalist. I've never worked in a school, and I'm certainly not a qualified teacher. So I spent a significant amount of time then trying to find out the view of someone who has the practical reality of working in one of these types of institution. And the closest I could find, or the only credible source really that I could find, that I'm aware of, is from an organisation called Special Needs Jungle, which is effectively something I suspect, Michelle, you may disagree with. I don't know. It is an organisation that is, in theory, set up to provide advice and support to parents of children, disabled children. One of the directors of that organisation is a lady called Gillian Doherty. And she's a campaigner for children's rights and manages a resource base in a secondary school. So she has practical, real-world experience of these things. And she wrote a very interesting article online that you can, if you Google the title on the slide, you'll find it, called SEN Resource Bases and Unit Provision in Secondary Schools. What are they and do they count as inclusion? Now, it's a genuine, actually really, really interesting article that I would suggest that people go and read if you are interested in this topic. It provides a summary of her lived experience of both types of provision, having educated children in both of them. And what she says is that SRPs enhance the educational provision of mainstream schools by catering for the needs of disabled children who are academically able. That from her perspective, what she's seen as teaching happening in a mainstream class, support provided by essentially staff who work for the SRP, and that students balance their time between mainstream classes and resource provision. In terms of SEN units, she explains that they support pupils whose impairment makes it more difficult for them to access a mainstream curriculum, but she does acknowledge that most of the core learning takes place in the unit, delivered, importantly, for a reason that we'll come back to, by unit teaching staff supported by TAs. And whilst she discusses in her article what she considers some of the positives, she does not shy away from the negatives. The first negative that she acknowledges being that segregation of pupils is a key fundamental problem. I haven't put the quote on the slide, but what she actually says is that disabled children get stuck in them, accessing hardly any of the education on offer at the school and spending an increasing amount of time with adult helpers rather than making friends and developing their skills with other young people. Now, if you think about what the DFE says an SRP or an SEN unit is, and you look at Gillian's experience, it is clear, I would suggest, that what the DFE suggests is happening is in fact what's happening on the ground, and that people who are operating in these environments are clear that it does lead to the segregation of disabled children from mainstream peers. Now, I put this in here, as I say, one, to give a practical reality of what's happening on the ground from someone who knows far better than myself. But the second question that I was asked to address by Michelle was how SEN units and SRPs are implemented in practice and whether there's an overlap. Well, I've already given you my view that there is overlap. The segregation of disabled children in mainstream schools is they are potentially being given just enough integration to create the argument that SEN units and resource provision are inclusive. However, I'm not necessarily convinced that if you look at it objectively, that is the case, particularly when you look at the evidence of someone like Gillian Doherty, who herself is clear that children get stuck in them. I mean, you can't really get any more stark than that. But from my perspective, the bigger problem is actually operationally, particularly in relation to SEN units, how they work, because in mainstream school in England and Wales, and it's different if you're going to an independent school, you are supposed to be, indeed there's a legal obligation, to be taught by individuals with qualified teacher status, or as most people call them, teachers. Now, the problem, as I see it, is if you have SEN units and disabled children are, to use Gillian's language, getting stuck in them and being taught by adult helpers, I am willing to bet probably quite a lot that those adult helpers are not qualified teachers. Certainly, if they're TAs, they are not. Now, and I question, as someone who practices in discrimination law, whether that is inherently discriminatory, because if you are a disabled child being taught within an SEN unit, it is because of your impairment that you are not having access to a qualified teacher. And if you did not have that impairment, then you would be accessing the mainstream class for near on 100% of the time. And there is, I would suggest, an obvious detriment if you are being educated by someone who is not a qualified teacher. And if you think about, from a legal perspective, what the elements of a disability discrimination claim are, unfavourable treatment by virtue of your protected characteristic, which in this case would be disability, then you start to think about, well, in fact, are these children being educated almost full-time in an SEN unit being discriminated against in comparison to mainstream peers? And I think there's a real argument there that that is the case. Bearing in mind the audience I'm talking to, I'm going to be quite careful what I say. But being a lawyer, I do consider that in most debates there needs to be an element of balance. I suspect that most people on the call abhor the concept of segregation within education, and there will certainly be people listening today who would argue that segregation within the education system is entirely incompatible with the principle of inclusive education. You may very well be right, and we'll come back to that shortly. But I did think that we should try to address some of the arguably positive things about SEN units and resource provision. And I suppose if we try to look objectively at it, what you could argue is that SEN units and resource provision are essentially meet in the middle provision. They are aiming to meet a need. They are aiming to integrate disabled children with non-disabled peers. The question is whether that works. Personally, I don't think it does for very reason that Gillian says. And in my caseload, I've seen children get effectively stuck in these settings without much integration. But my theory, I think, is if they were used effectively, then perhaps they could be positive because they could encourage integration. And if actually used properly, they might lead to greater integration within the mainstream sector. And when I think about that, I think, well, what's the alternative? Because I suppose there are two. Either you could have full integration of disabled children into mainstream, and there are many people, I suspect, on this call and who are not on this call who would say that that is what we should do. Certainly, I've had the privilege of living in other countries over the years, and I've lived in Finland. And there, the concept of inclusive education is completely different to how we would think about it in England and Wales. It's not uncommon in a Finnish school to see disabled children almost fully integrated into what they wouldn't call it a mainstream class, but what we would consider a mainstream class. The other option, of course, is what I don't think anyone would argue as being a good thing, which is complete segregation, i.e., taking disabled students out of mainstream education entirely. My honest view is actually I think both of those options would be potentially unworkable, potentially legally discriminatory, because if you have complete segregation for disabled children, then that is obviously discriminatory. But equally, if you are restricting educational opportunities by putting people in a mainstream class to try and encourage inclusion, but they simply can't cope, and then get detrimental treatment that way, that is potentially also discriminatory. So I don't suggest that there is an obvious solution here. Now, interestingly, thinking about the third question that I was asked to look at, the presumption of mainstream education, I think what the presumption of mainstream education is would support that view. So what is the presumption of mainstream education? Well, the presumption of mainstream education is a very specific thing, and it's defined in section 33 of the Children and Families Act 2014. And it's important to understand quite how specific the presumption in favour of mainstream education is, because it's something that is mentioned quite a lot by people, potentially by people who don't actually understand what it is when it is engaged as a duty. So what I would encourage, I'm not going to give you the full section of the Children and Families Act on these slides because some of it is waffly. I've tried to give you the key parts, but if you're interested, have a look at it in your own time. Google it, you'll find it really quickly. But section 33 of the Children and Families Act, the two key operative provisions are the ones on the screen. So subsection 1, section 33(1), this section applies where a local authority is securing the preparation of an EHC plan, that's an education, health and care plan, for a child or young person who is to be educated in a school or post-16 institution. Subsection 2, in a case within section 39(5) or 42, and I'll tell you in a moment in summary what that means. The local authority must secure that the plan, the EHC plan, provides for the child or young person to be educated in a maintained nursery school, mainstream school, or mainstream post-16 institution, unless that is incompatible with the wishes of the child's parents, or in the case of a young person, the young person themselves, or incompatible with the provision of efficient education for others. So from those two provisions, we can immediately see that there are limitations on when section 33 of the Children and Families Act is engaged. It only applies in circumstances where a local authority maintains an education, health and care plan. So it doesn't apply to all disabled children, only those who benefit from the EHC plan. Benefit perhaps being a questionable word. Only then disabled children whose needs arising from their impairments can't be met in provision typically available in a mainstream school in England, because it is only those disabled children whose needs can't be met in typical mainstream schools in England who are legally entitled to an EHC plan. And it is only in cases where the local authority has to pick the school that is included within an EHC plan that Section 33 applies, because if you look at separately Section 39 subsection 5 and Section 40 subsection 2, both of those provisions effectively give circumstances in which it's the local authority's job rather than the parent's job to pick the school that the relevant child should go to. So that is the circumstance in which the presumption in favour of mainstream applies, where the relevant child is a disabled child with an EHC plan, and where the local authority is picking the school that they are going to be educated in. In those circumstances, the local authority is required to secure provision for the relevant child at a mainstream institution unless it's against the wishes of the parent or the young person, or the provision of efficient education for others. Now, I don't think legally, morally is a separate question, I don't think there is any legal problem with restricting this based on parental wishes. In other words, if a parent says, I don't want my child to go to mainstream school, legally, that is fine. And that is because it is the duty on a parent and no one else in law, Section 7 of the Education Act 1996, to ensure that their child receives a suitable education. If a parent wants to make alternative arrangements for their child to receive a suitable education, they can. There is probably a debate to be had around whether parental choice is truly a free choice. That is a debate for another day. What is more interesting is the provision of efficient education for others. Because, in a nutshell, that means a disabled child with an EHC plan cannot go to a mainstream school if their attendance at that school is incompatible with efficient education of other children at the school. And this is where we start to see elements of segregation slipping in. Now, Section 33, subsections 3 and 5 consider this in more detail. You've got the slides there. So a local authority can only rely on the exception in subsection 2b, that is, that sending the child to a mainstream school would be incompatible with the efficient education of other children at the school, if it can show that there are no reasonable steps that it could take to prevent the incompatibility. And that's the same subsection 5 for the governing body, proprietor, or principal of a school. And that is because in England, and even more so now in Wales with their new ALN Act, the government's position is that all children, regardless of the severity and nature of their impairments, the needs of those disabled children can be met in mainstream provision. And if that provision cannot, on face value, meet their needs, then that provision should be able to be made suitable to meet the needs of disabled children. Now, interestingly, that sounds fairly positive. It suggests that the government considers we have an education system that can meet the needs of every disabled child, or that it can be adapted to meet the needs of every disabled child. But what's interesting is if you take a look in a document called the SEN Code of Practice, it looks into this in a bit more detail. and looks at the term reasonable steps. What reasonable steps are depends on each individual case. But what's interesting to me is that it allows local authorities and schools to take into account financial implications and the general disruption that taking steps to make a mainstream school compatible for a disabled child would lead to. It sounds fairly theoretical. If you want a practical example of that, there is a case from about 5 years ago, 2018, called AKT from Westminster City Council, and that was without going into the legalities of it, it was effectively parents of a disabled child wanting their child to be educated in a mainstream setting. The local authority said, we can't make the mainstream setting compatible to meet the needs arising from your child's impairment. The parent said, you can, you will, you have a legal obligation to do so. The local authority, which was Westminster City Council, said the only way that we can make this particular school able to educate your child is if we essentially build an SEN unit in the school. Now, in that case, the parents said, very well, you can build a SEN unit in the school for the child then. And they admire the gumption of it. They took it all the way to the upper tribunal. The upper tribunal said no. The SEN Code of Practice is explicit that local authorities can take into account financial resources. It is obviously not reasonable to expect a local authority to spend hundreds of thousands of pounds building an SEN unit essentially to educate your one child. Now, that's quite an extreme example, I accept. But it does show, I think, quite nicely where the competing priorities lie, because you have the presumption in favour of mainstream, you have a government that, well, not this government, but a historic previous government has ratified Article 24 of the UNCRPD that we'll come on to talk about in a moment, which says we can make an inclusive education system, but all of a sudden, when it costs too much to do so, the balance shifts in favour of not doing so. So it's interesting. But ultimately, the point remains that the presumption in favour of mainstream is not available to everyone. It is only available to those children who have an education, health and care plan and where the statutory requirements are met. But bringing that back to SEN units and SRPs, not a creature of statute, they are an executive invention or governmental invention created through practice. My view is that they do lead to segregation. That level of segregation will differ depending on the particular unit, SRP, and how they're operated. But insofar as a presumption in favour of mainstream is concerned, because an SEN unit and an SRP do not come under or meet the legal definition of a school, and therefore it's fact specific about whether they be named in an EHC plan at all. It's therefore fact specific in each case. If you could argue that sending a child to an SEN unit or an SRP is in fact compatible with the presumption of mainstream education. And in many respects, actually, thinking about whether an SRP or an SEN unit is compatible with the presumption in favour of mainstream education is largely irrelevant to the question of whether or not they lead to proper integration or segregation of disabled children in the mainstream education system. Lastly, then, we were going to look at the UNCRPD, the United Nations Convention on the Rights for Persons with Disabilities. It's a piece of international law, comes out of the UN, the purpose of the law is set out in Article 1. So in domestic legislation, things like the Children and Families Act, you've heard me refer to Section 33, the presumption in favour of mainstream. we have sections in the law domestically. International law is much more grand. They don't have sections, they have articles. So in the UNCRPD, Article 1, the equivalent of Section 1 in a piece of English law, sets out the purpose of the Convention, which is to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote respect for their inherent dignity. It was ratified by the UK in 2009. That's the government saying we agree with it, we want to implement it. And its principles are broadly met through various pieces of legislation. So things like the Equality Act, parts of the Children and Families Act, etc., bring the principles set out in the Convention onto a domestic English level. And interestingly, if you look on the House of Commons website, it was acknowledged by the government of the time when they ratified it that by following the convention, the UK agrees to protect and promote the human rights of disabled people, and they're explicit, including ensuring an inclusive education system. So there is an explicit acknowledgement there. And they didn't do this about every single, I mean, there's loads of articles in the convention, loads of principled pieces of protection for disabled persons. The one that the government picked on when it made its statement was the right to an inclusive education system. Very interesting because of the last word on the slide, which is restrictions. Now, I'm not here to give you a law lecture, but when the UK government decides to ratify a piece of a UN convention, it has a right, in theory, because the English government has the right to, or the English Parliament has the right to decide what the law of England is, to restrict the ratification of certain parts of the convention. In other words, Parliament can say, we're happy to ratify the convention, but we will only do X, Y, and Z of it. We won't do the whole thing. And that is exactly what the UK government did in respect of this convention. It is one of two governments to have put restrictions on the implementation of it. The other one, incidentally, is Mauritius, which obviously used to be a UK part of the UK Commonwealth. And they were the only two states who ratified the convention that placed restrictions on it, one of which, in the case of the UK, was on Article 24. Article 24 will hopefully be familiar to some of you. It's the right to inclusive education. Article 24, subsection 1, state parties recognise the right of persons with disabilities to education with a view to realising this right without discrimination and on the basis of equal opportunity. State parties shall ensure an inclusive education system at all levels. That is unequivocal. State parties shall ensure an inclusive education system at all levels, i.e. nursery, primary, secondary. Article 24.2 gives a bit more flesh to the bones and explains what that means. So in realising this right, and there's a list you can see on the slide of what that means. Now, interestingly, in Article 24.1, note the end of the second sentence, state parties shall ensure an inclusive education system at all levels. One of the restrictions that the government used when they ratified Article 24 was in relation to the definition of education system. One of the restrictions imposed allowed education system in England and Wales to be defined by reference both to mainstream schooling and special schooling. In other words, the government said, yes, we're happy to ratify Article 24, as long as when we do, it is compatible with the education system on the ground in the UK, which does have this element of segregation in, and therefore education system must be defined by reference to that segregation. Now, Article 24.2, as I've said, gives detail about what an inclusive education system is. And my view is that SEN units and SRPs are not compatible with the right to inclusive education under Article 24. And I say that for a number of reasons, but if you look at the list, A, persons with disabilities are not excluded from the general education system on the basis of disability. Well, we know, and the government accepts, that children who are educated in SEN units and resource provision are, for part of their education, excluded from the general education system because of their disability. We know that that is not inclusive, so it's contrary to point B. Arguably, it is in accordance with point C because it does, in theory at least, accommodate disabled children's individual needs. D is contravened because the children do not receive the support required within the general education system. They are removed from mainstream classes. So, generally speaking, my view is that SEN units and SRPs are not compatible with the right to inclusive education. The next question then is, does that mean the UK government is doing something wrong? The answer to that is no. And that is because they were clever in how they implemented it with the restrictions. In requiring ratification of the UNCRPD with restrictions in place, by defining education system by reference to the segregation that's inherent in the English education system, it means in reality the government can do exactly what they are doing. They can have SEN units in place, they can have resource provision, and they can require disabled children to make use of them. And therefore, at least in theory, whilst SEN units and SRPs go against the spirit of inclusive education, the way the UK government ratifies it has meant that in theory they're doing nothing wrong. They're not breaching Article 24 by operating the system as it is operated. Finally, then, going back to the 4 questions that I was asked to deal with, there's no legal distinction between SEN units and SRPs because they are not legal creations. There is some overlap between them, but there is a practical difference in how they are operated in schools, both on a theoretical level and a practical level. Whether either are compatible with the presumption in favour of mainstream education is entirely fact-specific, on a case-by-case basis. And in terms of the UNCRPD Article 24, the right to an inclusive education, no, they are not compatible with the spirit of the convention. And that is probably why in other countries that have ratified it, you don't see necessarily the same kind of education system. But they are compatible, in my view, with the government's legal obligations as they apply domestically. So there's very little you can do, in my view, to challenge the UK government for an arguable breach of Article 24 of the UNCRPD.